Hello, hello, hello. This is Attorney Mike Gravel coming to you from Chicago as usual. And this is what happens when I behave myself on Saturday night. You end up with something like this. I just wanted to get a stream in where we did some wild court moments before we get back to the craziness that is the Brooks trial. Yeah, I wanted to show you all my cool present. You guys were talking about it in the chat. Griggs, thank you, Griggsy. He got this for me. It's Metro State. It's fantastic. It's even signed by Jeremy DeWitt himself. Griggs and I had a little chat about it. Standing out on division. Apparently, he negotiated this deal with Jeremy's mom. I already have the perfect place for it, but I don't know how to put it on. But I mean, I think it's got to go right on the fez. I mean, we need the tassel for full effect here. Here. You see where I'm coming from, right? I mean, it's a thing of beauty. That will be the ultimate thinking cap. A Moor fez with a Jeremy DeWitt. What does it say here? Motor officer patch on the front. I can think of nothing better. All right. Let's get to the clips here. I promise that this is Brooks free and thruple free. Brooks free, thruple free stream. Let's do it.
Ma'am, you didn't say the cat jumped on his wiener, did you?
Yeah, without getting into further detail, there were drugs involved that people were giving to me that ended up being glue. Like I smoked some glue and stuff. I thought I was smoking crack. And
don't say a word. Oh, and go ahead and put yourself on mute now. This received international attention.
International attention.
Okay, I'm assuming that's a yes. Okay.
This poor guy. He's just trying to have his court appearance. He's not the
Sir, you need to have a seat. You need to stay sit. You need to have a seat and you need to stay there. Stop just wandering around thinking you just can do what you want. You can figure it out right there and sit.
It gets a little cursy, as you might imagine.
That mumbling, I can't understand you. If you're gonna talk shit, go ahead and talk it.
That was the guard. I did, I think. I don't know where this is. I really don't. I don't know who the judge is either.
Baby.
Oh, have one for me. It's a medical thing.
Well, that would make sense. It does say Knoxville in the room.
I'm just trying to catch, the reason why I'm fucking new is I'm trying to catch a goddamn real charge to see why the fuck I'm here. Hey, man. I'm trying to catch
We want a real charge.
for somebody to keep it.
It's bogus. It's been going on about 3 years.
Hey, Brad, first off, you can shut up or I can go back to the closet.
Yeah.
And you can go back up to your fucking cell and you won't do your regular. There you go. Have fun staying in jail. Yeah. Bye now. You don't have to fucking stop running your mouth. Bye. Branch, you come here. Yeah. That's all right. I love being here. Yeah.
I really like the guy whose case it actually is. He sits there quiet the whole time. He conducts himself admirably under the circumstances. You still can't hear me? That's probably even better. My number one comment is to shut up.
What's your medical emergency? Or is it just your dick? Yeah, that's probably what it is. Branch is gonna sit in the slaughter. One of these guys just said he's gonna catch a real charge. Some other chick just blurted it out randomly. I don't know if he has fucking attitude, but then Branch said, "Yeah, I'm gonna catch a real charge too." So they're being really loud. I'm not talking, so I just sent the other guy back to his cell. No, not yet. I'm just keeping him there for a minute. All right.
All right, sir, I'm going to find that you qualified for an appointed attorney. Excuse me, I'm going to appoint the Public Defender's Office to represent you in this matter. There's a $50 assessment associated with this appointment. That should be paid to the clerk's office on or before.
Well, ostensibly, a bond hearing.
October 31st. If you're not able to take care of that, it probably would be added on as part of your court costs. I set your bond in this case at $1,000. However, there are other bond conditions. While you're on bond, you're to have no contact whatsoever with Chandel Robinson. No phone calls, no text messages, no communication through Facebook, Snapchat, cell phone, text messages, emails, third parties. She is to think that you have dropped off the face of the earth. You're supposed to stay away from her home and any place where she's likely to be, which means if she has a grocery store that she goes to, you need to go to a different grocery store. While on bond, you're prohibited from using or possessing a firearm. And while on bond, you're prohibited from possessing or consuming alcohol or controlled substances.
Those are rough conditions.
I'm scheduling your case for October 19th. That is Wednesday. At that point in time, your lawyer will be able to approach the judge about a reduction in bond or a change in the bond conditions. So if you make bond, first thing you need to do is make contact with your attorney at the Public Defender's Office. If you don't make bond, your lawyer will be able to maybe get that bond reduced or place you on recognizance when you go to court on Wednesday. Do you have any questions?
My bond is how much again?
$1,000.
Okay.
Any other questions?
Yes, one question.
I need one. No, sir.
Very well. Your arraignment is complete. Your name, sir?
Amarion Wright.
Oops, I think I meant to cut this part out. We'll just get a little more flavor.
Oh yeah, you're right.
And don't forget to hit like and subscribe, or the dogs get it.
Questions?
I don't think so. I think that's it. Thank you.
Very well. Your arraignment is complete.
Can I call someone so I can get my bond? So I'm ready.
You guys still can't hear me? I turned it up. Oh well. This next guy is a trip. Brace yourselves. This is good.
Branch, come up here. Who?
I'm on the so I'm logged up.
It's on our heart. I mean, you can attempt it. It's working.
I can show it now.
Your name, sir?
Harold Branch.
Mr. Branch, you have a right to remain silent. Anything that you say could be used against you in court. You have a right to be represented by an attorney. If you cannot afford an attorney, one can be appointed to represent you.
Let's make a phone call.
You have a right to have a hearing where you can present witnesses and evidence on your own behalf, and you can question any witnesses or evidence.
I think I found the problem.
You understand
They're
your
going
rights?
to have some evidence. There's going to have to be some evidence of something that I'm not charged for nothing.
Sir.
Yeah,
Listen,
yeah.
do you understand the rights that I've just explained to you? Can you say yes?
These guys are having bond hearings. They're already in custody. So they're doing it this way, but they're doing it in the community room, and it's a nightmare. This time, last time it was just the guy distracting. This time it's the guy responding, the actual case that's more interesting.
Yes, sir, I did.
Okay, very well. Did you fill in one of these forms?
No, I'm sorry, I wear reading glasses.
I
You
didn't
fill
have
in
the
one of
mic
these
on.
forms?
No, the officer did it for me. I wear reading glasses.
Okay. I wear them too. Did you read through it?
No, sir, I did not. I wear reading glasses. The officer filled it out for me.
All right, please raise your right hand and be sworn. Do you swear the information that's on the form, to the best of your knowledge, is true and correct?
I do.
Are you employed anywhere?
No, sir.
Do you own any property?
No, sir.
Are you going to be able to post bond or hire an attorney?
No, sir.
How long have they had you there?
Pardon me?
How long you been in jail?
Yesterday at 1 o'clock.
209-5488.
How many times do I have to go to jail before I know what I'm doing? I want to see something on paper, what I'm charged for.
Well, sir, you're charged with criminal trespass.
Okay? Tell me
Now
this.
you know.
How come I don't have anything saying no trespassing? Here's what the deal is. The owner of the laundromat sent me a thing saying people was in fear for their life. I want to know who the people are that's in fear for their life, and I want the people that own the laundromat to go to court with me and go against me. Tell me something. See, they keep telling me they're going to. They don't do it.
I don't know. Based upon your behavior right here in this hearing, I find it entirely plausible that people are afraid.
Nobody does it. So the police told me she done this and she done that. I said, she don't own the laundromat. She cleans the place. That's it. She's the cleaning lady. So she has nothing. You know, when I ask somebody something, they don't know. But supposedly that woman was to say that I was at the laundromat. Well, that woman just works there. She don't own it. I know the owners. There's 3 of them and they own more than one. You know,
Yes,
they're not mates at laundromats, but
it's hard to hear.
But I want to go to court. I want to go to court against them, sir.
Very well.
They have no right saying people is in fear for their life. I've never made people feel in fear.
Yeah, they do. Yeah, they do. You might defeat it in court. That's the process we have. I like you said, I want to go to court. Well, yes, plead not guilty. That's you're currently in court. It's just a bond hearing, but you're headed for court. He's supposed to set bond and tell you what your next date is. That's what we're doing here.
Fear for their life. Never. So that to me is offensive. I'm going up against them with everything I got in me. That's why I keep going to the laundromat, sir.
That's an odd flex. I'm going to go up against him with everything I got after he just had to disclose that he doesn't have anything so he can get a public defender. I'm sorry. The irony is just too much for me.
Can you tell me how long you've lived in the Knoxville area?
Since I was 16 years old.
That doesn't tell me how many years.
You do the math. I'll be 63 the 24th of November.
Well, sir, I'm not a mathematician. That's why I'm
Well,
asking
I've been since I was a kid, sir. I'm 63. I've been here since I was 16.
Brandon, calm down with the
Well, I don't have a calculator either.
I'm giving John the day off. I think he'll be with me tomorrow.
It's not fun. It's getting old.
No, I'm tired of seeing you here.
I'm tired of you.
I guarantee it.
You gotta remember to do something.
You negative. Sit up to yourself on Miles.
I don't have a record. I've been here since I was 16 years old, and I've had a few PIs when I was young and DUIs when I was young. Excuse me.
Yeah.
I'm sorry for being upset, Your Honor, but this is bogus. The police have busted my door down and taken me to jail in my underwear and T-shirt, for no reason.
If he's got a door to bust down, why is he trespassing the laundromat? That's my. I mean, I don't know if that's true, if that's delusional, but that's what I can't put together here.
I'm sitting there drinking a cup of coffee, and they get me, bust the door down, handcuff me, and take me to jail. Now that's a laundromat. That's at my house.
Thank you.
Now I thought they only busted people's door down when people killed people. That's private property, and there's a sign up there. Now somebody's gonna get hurt over this ordeal. It's went too far. I'm 63 and I don't feel like being tormented. I feel like that's what's being done to me. I'm being tormented.
Who's speaking? Hello? Okay, yes, I'm calling my sister got my money. She's trying to get up with my money. She got my mom, but
Let me drink water.
Wait till you're arraignment, then you can get a drink of water.
Huh? Oh, this is Landon Robinson.
He really does look like that commercial. Oh, that's funny.
Okay, you got any other places I can go?
Well played.
But what?
Yeah, they supposedly say they're gonna go to court, but, I don't ever see anybody in court. I wanna see somebody in court.
What about Sanford?
Has anybody ever talked to these people at the laundromat?
Sir, I'm a magistrate. I am not an investigator. I'm not a DA. I'm not a prosecutor.
Okay.
So it's not my job.
I know. It hurts. It hurts.
This is Landon Robinson family, Knox County, in Pinnacle. I got a bond of $1,000. My sister got my, which is 10% of me, like $100. She got my money. She just trying to get in contact with the bond company so she can come down. Well, she just gonna give you my money so I can do that. Landon Robinson. Yes, Landon behind. Robinson. Our number is 865-446-0046.
Do you maybe know why the police department just shows up out of the blue and takes me to jail for no reason whatsoever under the sun?
No, I am not keyed in on police department motivation.
Okay.
Okay, please, man. I got y'all to do work tomorrow. Please.
Thank you, Kathy Richardson. And welcome
I
aboard.
just
to new
felt the need to
members.
say that.
Thanks,
It's
Kathy.
being done. I didn't just get to be 60 years old and decide to be a criminal.
No, it was a lifelong commitment.
All right, sir, I'm going to appoint public defender's office to represent you in this case. I'm going to waive the administrative fee because I see they're already representing you in another case. I've got to set this case for October 19th. That'll be in misdemeanor court regarding a bond hearing. I set your bond at $1,000 with a condition to stay off the premises of 2900 Washington Pike while on bond.
No, he did not.
As I say, the 19th in misdemeanor court for bond hearing. And your bond in this case is set at $1,000. My hands are tied to some degree because you have pending cases of criminal trespass, which state law requires that I enhance the bond significantly
Sir?
due to those pending cases.
Uh-huh. When am I ever being charged? I'm doing time.
You are charged now, but October 19th is your court date for getting something done with this bond.
You just got charged. He read the charge to you. They ask this all the time. I feel bad for him. A public defender could probably spring him, but and he just got appointed one, so that's it. I feel bad because there are criminal trespass charges. And I don't know the facts on the ground, but I'm guessing it just got to a point where they had to deal with it, and he's getting multiple, so he probably doesn't have a place to go. I feel bad for him, but it's got to get worked out.
That I don't have a choice about.
Sir, my house is open. Every window in my house is open.
But here again, he's trying to get out by saying the windows in my house are open. I need to go. And for these sorts of charges, I'm surprised he can't get bond. I think he said $1,000 bond, which I think he can spring himself for $100. So, that's where we are.
Sir, I have no control over that.
Oh, nobody seems to have any control over anything.
Your arraignment is complete.
Take you in your mouth, for instance.
All right, Branch, head over to that slider. You can get you up some water. Thanks, sir. Have a good night.
No, I can't post bond. I ain't got no
Okay. Okay.
Irwin v. Irwin.
Okay, so that was jail court. I also got this. It was sent to me. Thank you. It's just kind of fun. It's Judge Marilyn Hahn. I think this is Washington. I think this is Cowlitz County. I'm not even sure, but this poor father, I can't tell how bad he is. They make a compelling case against him, but he doesn't get to speak. You'll see.
One, we have Mr. Sandy, and do we have Travis Irwin?
Yes, I'm here.
Okay. All right. Counsel, go ahead.
And thank you, Your Honor. As the court's aware, I do represent the petitioner and the moving party to the contempt motion before you today, namely Julie Wright, formerly Irwin. I would start by stating that we did not receive any responsive pleadings from Mr. Irwin, which is somewhat alarming given the circumstances that have unfortunately led to the submission and the filing of this motion. I don't know that the court received anything in response from Mr. Irwin, but my office did not. If we move forward to the basis of the contempt action before you, I think it's pretty clear on its face what's happening. I think unfortunately Mr. Irwin is pretty transparent what his ultimate goal for this is related to this 15-year-old child who is being manipulated and controlled by dad to a degree which, frankly, I have not seen in several years, and that's very disturbing. If you look at paragraph 14, again, I think the language is quite clear. It's language that goes in 90% of the parenting.
You froze, Mr. Sandy. Okay.
Your Honor.
No,
I don't know if I'm able
nothing
to
at this
talk now.
time. I need to have Mr. Zandy finish.
Okay.
Which have already been agreed to by both parents in advance. And then it concludes by stating that neither parent shall encourage the child to change his primary residence or encourage the child to believe it is his choice to do so, choice that's made by the parents, or if they cannot agree, the courts. We have provided you essentially the tip of the iceberg as it relates to the communications in this. We've given you examples of what my client is unfortunately being subjected to, and more importantly, what the child is being manipulated into. We've given you kind of the biggest, greatest hits of what's happening right now, which includes Mr. Irwin finding it appropriate to take the child with him to an attorney's office who does domestic relations law. My client has, as most parents do, one of those apps on the child's phone, which shows where the kid is. Come to find out the child is with dad at an attorney's office a month or two ago, sitting through an approximate hour-long consultation, which involves the child. Frankly, I think that is disturbing, to say the least, in its own right. That is directly putting the child in conflict. That is directly informing the child of what's happening. And that is essentially coaching the child, saying, hey, come tell him or her, this attorney, as to what it is that you want. That's directly involving the child in the litigation process, directly involving the child in a process that is not subject to Landon's privy. That is between the parents, or as the order states, if they cannot agree, the courts. So that seems to be very obvious. Clearly that is willful, clearly that is intentional, and it's about as egregious of a violation as I would assume one can get of that provision. If you look further and you look at kind of what's happened over the course of the summer with Landon, my client details for you, this has been a relationship that she's had with her son, which has always been very good. Landon is well cared for. She's been the primary parent of this child for a significant period of time. And now all of a sudden we've evolved into a 15-year-old who suddenly turns off from mom. You know, we turn to a 15-year-old who has a conversation with his dad on the phone. And then strangely, within a couple of hours of that, my client finds out that the child has essentially deleted all the text message and incriminating evidence from her cell phone as well as her husband's cell phone in the color of night, which again can only be attributed to dad's influence on this 15-year-old child. Again, that seems highly inappropriate. That seems as though you are coaching the child again to get involved in this and to make it known that, to get what you want, here's what we need to do, which is interesting when you look at the basketball of this. It's all done strategically. You've got Mr. Irwin, who then, and we've attached the text messages and the communications between him and my client saying, as it pertains to basketball, as it pertains to this trainer, we're going to do it my way or no way. We've got Mr. Irwin, who then manipulates the child further and says, you always play, like, pardon my language, shit when your mother is in the stands watching you. When your mother takes you to these basketball games, you don't play nearly as well and your performance suffers. This is a child who loves basketball, who wants to be good, who has aspirations of playing in college. And we have dad who, again, can be called nothing else than manipulation of this kid saying, you play better when I'm there. You don't play nearly as good when your mom is. And he's putting this in text message to this child. We have information, a declaration filed by Landon's coach that says Mr. Irwin is obnoxious at those games.
Okay, so here it's already all over in the chat. Why doesn't he have an attorney? You'll get to that. And this attorney representing mom is doing a fantastic job. He's really good. But all that he's saying, I'm thinking of, and I don't know the facts. Maybe they aren't there, but I'm thinking could be countered by another good attorney. So I I do see where there's a bit of a problem that he's not represented. You'll see how she deals with it. But no, you've got an excellent attorney just pounding him senseless and making damn good points. Does he have any counter arguments to that? We don't know, but he's certainly not prepared to address it himself against an attorney of this caliber.
That he influenced his child. He uses the term abuse with that. We have these actions of Mr. Irwin, which again are geared towards Landon in very unhealthy ways. And again, it comes back to taking your child with you to an appointment involving the residential schedule, the same one that specifically restricts him from doing that and involving the child in this type of matter. So again, it's very clear, it's very evident what's going on. We have the messages, again, via text message that we've sent you, which states that Landon is now being told not to tell my client certain things, essentially keep secrets from your mom, because this is all part of the master plan and the master strategy to have you arrive in my primary custody, because essentially we're buddies. That's the relationship he has. He goes so far as to instruct the child, hey, your mom doesn't need to meet your girlfriend, but you can have free access to your girlfriend when you're at my house. Keep that person a secret from your mom. We'll maintain the relationship. I'll give you what you want. But again, the ultimate goal is that you're going to come live with me, and I'm going to stoop to any low level to accomplish that prerogative. Again, what's the course of that? We now have a 15-year-old child who is resentful for mom for reasons that we really can't pinpoint outside of dad's influence on him to a very significant degree. Quite frankly, it's disgusting. It needs to stop, and this was brought as a last attempt measure to get it to stop and to get it to cease. My client should have the relationship with her child that she's always had, not the one that occurred at the beginning of the summer when dad decided that he's going to pursue primary custody. Although we have no indication of that, nothing's been filed, one can only assume that that's what dad is logically preparing for. Again, his contacts with the child, the messages to my client, which he's bullying her, that's the only way to really describe it, and saying, I'll take care of the basketball stuff. It's a joint decision, but I'm essentially going to do what I want to do. Oh, and by the way, I don't want you to contact Landon's trainer. That's subject to me. We have this information that Mr. Irwin even gets angry and upset when my client's husband, who again has always had a good relationship with Landon, tries to take him to a Portland Trailblazer game. Mr. Irwin says, no, that's not appropriate. Basketball is what I do. That's between me and my son. I don't want you going. That's very domineering. It's bullying to a large degree. And the effect it's having on this 15-year-old child who's not mature enough to know what's going on, only knows what he wants to hear in the moment. Dad is grossly manipulating him and grossly pressuring him to put him in a position to think it's his choice to choose, when the very language in that parenting plan cites the specific contrary of that. This is egregious. This is obviously willful. It's obviously intentional. It's obviously be done as part of this strategy. So Mr. Irwin can subjectively get what he wants, and it absolutely should not be tolerated because, again, it is very egregious behavior. We are asking for a finding of contempt. We're asking that my client be awarded the attorney's fees and sanctions requested in her motion. That would be $1,500 in attorney's fees payable within 60 days of entry of the order, along with what we would call a hefty civil penalty, because again, where we're at right now requires, and it's appropriate to impose a significant hefty penalty because of the conduct of Mr. Irwin that continues to impact this child and impact this child's relationship with his mom. Both parents should have a strong relationship with this child. Both parents should be a united front when it comes to raising this child in Landon's best interest. And Mr. Irwin is doing absolutely everything in his power to sabotage that, and it should not be allowed or permitted. We are asking the court to send a strong message to him today because this is, again, not to overuse the term, but it's absolutely appropriate, egregious behavior.
So, Mr. Irwin, I do not have any written response from you. That means that I can't hear a response from you. This is done on writing. And the problem is you were served back on September 29, and here we are on October 11. So
Correct.
there was plenty of time to file a written response.
I actually didn't know how all the process works. I was actually hoping to show up here and ask for an extension because my searches for an attorney has come up with nothing. I've searched, called. I'm actually waiting for about 3 more phone calls back from an attorney. I'm getting that they're not accepting new clients. They are busy. Conflicts of interest. I was hoping to have one before. One just called back right before we got on here. They are not in Calais County right now. I'm waiting for 2 more callbacks to hopefully find something. That's why I don't know how it all works. I didn't know I needed to respond somehow. I read the papers and I figured that's what my attorney would do, but I do not have one yet.
Mr. Zandy?
Perhaps he needs to not take his kid to the attorney's office. That would be certainly a start. So that would be first and foremost. Second of all, I think if you look at the service issue, and we filed information that says we were finally able to get him on September 19th at 7:28. Prior to that, our normal process server made several attempts. And I'm looking at the document that was filed on September 23rd, a return of non-service from Michael Gilman. States he attempted to contact Mr. Irwin on the 10th, 11th, and 12th of September with no response. Finally saw him in his green Jeep on the 15th of September. Asked him if it was him, and he said, nope, I'm the neighbor. Proceeds to get out of his Jeep and go into his house. So
that's not true, sir.
Stop.
It's clearly a situation in which he's doing everything in his power to frustrate this process. And it states in the motion.
Mr. Zandy, you need to keep your video off. It doesn't work with your video on. You froze again, Mr. Zandy, so you need to turn your video off.
In any event, I think the last thing that was stated that might not have been on the record is it was in his own words through the text messages and the communications as to what's going on here. It's pretty clear.
So I'm looking at the fact that this was served some time ago, that this is very egregious as to what is going on. So we are going forward today. And based on the files and record, this court does find a willful and intentional violation of the parenting plan by the father, and thus he is in contempt of court.
Your Honor.
I am not going to continue the case. You had plenty of time to do a written response.
I've had it for 2 weeks, and I've been waiting for phone calls from multiple. I've called almost every law firm in Calais County, and I've gotten no response. I'm even into Vancouver and other areas, and I'm waiting for callbacks. I finally got a...
I believe him here. I believe him, and everyone will get mad at me. I think that this guy's made a lot of mistakes and done a lot of bad things. I think that the relief they're seeking is probably warranted. That is my guess. That is my guess. But he got served with a petition from this guy who knows what the hell he's doing and is good. And I don't know how hard it is to find an attorney, but it wouldn't surprise me if it's hard to find an attorney in that area. It would not surprise me. So what I'm saying is that this is a plausible argument to me. Maybe he's at fault for all of it. Maybe he's at fault for some of it. I don't know. The attorney for the mother certainly makes a very compelling case. I would like to see him represented to defend himself in that. I still think that they probably get some of the relief sought. I do. But I don't think that this guy is completely not trying. I think he's made some mistakes. I think that the argument was compelling, but there's probably counter arguments as well. I don't know, but I'm not certain that she's been perfect either, but there's no one there to step in and help. So that's where we are, and that's exactly what the judge is grappling with.
I called back today, and I had called them a week and a half ago. And they finally called me back today to say we are not accepting new clients or Calais County clients. I'm searching for one. My attorney that I had before, she's got a full schedule. So she was not able to take it. A lot of the accusations on the papers are
you can't do it. So here's what I'm going to do.
I don't know
Stop.
How am I supposed to know I can't do that if I don't know how it works?
Mr. Irwin, stop. So I will go ahead. Mr. Zandy, I don't like this, but at the same time, I need to make sure that both parties are heard. Because I will continue this, but if there is any act of involving this child before this next hearing, I am going to consider looking at limiting your time with your child. This is egregious, what is being alleged. I understand it's allegations, but do not involve this child in this litigation. The child has the right to be a child and not be involved in what is going on between you and the mother. So again, if I hear or see any other text, anything that is demeaning, that does not follow what is required of you, the court will consider limiting your time. So I will set this over to October 25th. You either have an attorney and have responded, or we're going forward that day one way or the other. Do you understand me?
Yes, ma'am. October 25th?
At 9 a.m.
Fees for today, Judge, you just want to take that up on the 25th?
On the 25th.
Okay, thank you.
Okay, does that mean we're done?
We are.
Okay, thank you.
Okay, I thought that was an interesting one, and the judge was, in the end, I was fascinated to see what she would do, but she's exactly where I was. She's listening to this saying, she didn't say all this, but it's clear to me, you know, I tend to believe the case that's being put before me right now, but for instance, he didn't know he has to respond in writing. That's not surprising. Even if he did know, this guy put together probably a complex petition that's very well done, and he's got no chance of responding to that properly and then arguing properly against it. He doesn't. I'm just telling you. I'm just telling you. So if this guy's truly trying to get an attorney, and we're talking about 2 weeks. This isn't like, oh, I've been kicking this around for 6 months. No. We're talking about 2 weeks. You got to get an attorney to respond to a heater petition. Not so easy. That's possible. So the judge, I was impressed with her. I think this is the first time I've done a video on her. Maybe not. She looks familiar, but it doesn't matter. The judge is exactly where I'm at, which is I'm inclined to believe everything about this petition. The argument was excellent. I am 95% there and just granting the relief requested. However, I would like a proper adversarial system where an attorney who knows what they're doing has had a chance to look at it and respond. That would make me feel a lot better than just saying, oh, you didn't know how to respond in writing to a complex petition, you're hammered. No judge wants to do that. You don't let it kick around forever, and she didn't. She gave a short continuance and said get that attorney, or she didn't say it, but she implied, or all this is whatever they're asking for, they get. That's certainly the sensation I got from the hearing. I don't know. Thank you all for. Oh, we've got more. Hi, Nigel. Yep. Nigel gets it. I mean, I don't even do this, but if someone came to me and said, "Oh, okay," and it's not like you get it day one. Let's say you've got a week left, and you have to respond to this. I might just, and I'm busy or I'm unsure. I'm like, I'm not doing that. That's a heater. Let me see here. Oh, let me get to the bottom, make sure I don't miss. Oh, there we go. Debbie was on with us the other day. She stopped into the stream at one of the most horrible times. I'm like, come on, get on, and then just so happens that's when she was available, and it was a rough point in the Brooks trial. But yes, I've heard from Debbie. Debbie's my buddy. I always hear from Debbie. All right. Well, thank you all for coming out. I just wanted to do a non-Brooks stream because it looks like for the next day or two that will dominate things again, which is super interesting. I actually miss seeing Cedric Simpson and my usual cast of characters, Judge Middleton and all that crowd. Oh, let me see here. first ever super chat. Love your channel, Mike, and look forward to your color commentary for tomorrow's Brooks trial. Thank you so much. Thank you for the super chat and for the nice placement. Everyone come by. I think we'll do that. I don't know. Ben might be by too. I've been chatting with him. I've suckered a lot of people into this one. I've had so much support. Obviously, John has really co-captained that deal, and frankly, sort of drugged me into it. That's okay. I drug him into making a YouTube channel. He drugged me into that. I think we're even. All right. Thank y'all for coming out. I will see y'all soon.